Hi, my name is Jeff Fowler. I'm the president of the Apartment Owners Association, and it's such a joy to have you with us today. And man, they've made it so complicated to understand LA County, LA City, how all this works together with renter protections and evictions, and when you can do a rent increase, when you can collect the rent. And so that is our topic today. And so anyway, if you are wanting closed captions, you can go to our Facebook page, and there's closed captions there for you if you're watching live. And of course, AOA is the largest individually organized groups of apartment owners here in the state of California. And wow, you know what we're trying to do. Our biggest goal is for you to be successful, and we're trying to give you the content that you need, the education that you need to avoid the landmines, and to also find create systems that will help making property management easier for you. Whoa, okay, here we go. And I'm glad this is live, right? And one thing I want to highlight today is that we do have a contractors and vendors search engine. And so check that out if you go to aoausa.com. And if you go to, there's a contractors and vendors tab. So you could go there and type in a specific field. Maybe roofing is a good one for today with all the rain that we've had. And so you could go there and look, and it will give you a list of the roofers based on the proximity to you. So anyway, if you haven't joined AOA, I want you to know that there's a free money-back guarantee if it's within your first year. And also, it's a flat fee. It's $97 a year, and that's a flat fee. There's no per-unit surcharge for you. And isn't that a wonderful thing not to have to do that? All right. So we have on March 7th coming up in San Diego a property rights roundtable. We would love to have you there. Space is limited, so please register for that event as soon as you can. We have the trade show coming up. If you can believe it, we're less than 2 months away. That's going to be on April 19th at the LA Convention Center. And that event, you'll walk away with a lot of questions answered, I believe, and some good ideas to help you make and or keep more money than ever before with your real estate investments. And then next week on the live stream, we do have the legal Q&A for the Bay Area. So if you're in the Bay Area, that's really the time to tune in. This one here is really for LA County. And then some things you may have missed. Actually, earlier today, we had the common California Building Code violations. That was part 3 in a 3-part series, and it was just rich. And I think we all have different lenses to view things through because of that video. If you haven't seen it, you got to go see it quick, because we will take that down and make it so that it's only available to members. And along with the other 2 parts, along with Michael Brennan's habitability video. And so that 3-part series plus the habitability, it's just super important. And again, because our goal is to have the most successful group of apartment owners in the state of California, that's specific information that we want to reserve for you. And so you'll be able to get that, I believe, by tomorrow. It all should be loaded in the member portal. All right. And again, just want to give a big shout out and thanks to S&S Law Group that made this video possible today. And they cover landlord-tenant issues, business, corporate, and real estate law. And they cover, I'll let our speaker today share more about their business, but they do cover not just LA County, but Orange County and Ventura County. And so you'll want to check them out as well. And so our speaker today, he's been practicing law for over 10 years, and he graduated both from UCLA and USC, and he's able to walk the tightrope on that one. He got a Juris Doctorate from the Gould School of Law at USC. And anyway, he covers a lot of different things: breach of contract, breach of fiduciary duty, partnership of shareholder litigation, unfair business practices, and misappropriation of trade secrets. And he has a strong legal and financial background that gives him expertise to successfully litigate complex real estate, financial, and business disputes, and the knowledge to counsel clients on multifaceted business transactions. And so it's my pleasure to introduce to you today Edrin Shamtob. All right, Edrin, why don't you go ahead and share with us?
All right. Thank you so much. I just wanted to thank you for the opportunity to be here with you and your wonderful audience. As a little bit of a background, and today I'm going to be speaking about a wide range of issues impacting both landlords and tenants, focusing mainly in Los Angeles County and the city of Los Angeles. But before I get into that, let me just do a very short introduction. My firm is S&S Law Group. I've been a practicing attorney now. I've had the good fortune and the privilege of being a practicing attorney here in California for about the last decade. My practice focuses on eviction actions, unlawful detainer actions, real estate litigation, and business litigation. We're trial lawyers here in my firm. We file actions, we aggressively pursue those actions, and we try to promote the best interests of our clients and get them, the end results that they're all looking for. So just to provide an overview, I'm just going to have a pretty short discussion here on a few different topics that's probably top of mind for AOA members and a lot of residents here in Los Angeles, both on the landlord and the tenant side. The topics are going to be the RSO requirements in general. We're talking about rent stabilized properties in the city of Los Angeles and the county of Los Angeles, the various moratoria that have been in effect, some of which continue to be in effect. Probably one of the most important issues for our listeners here today is recovery of rental debt, the back rent that has accumulated over the past 3 years since the onset of COVID. And then some specifics on when landlords can increase rents and alter other terms of tenancies. And then finally, I'll have a brief discussion on some of the more creative solutions options my office employs to try to get out those pesky tenants so we can return these properties to landlords and they can put it to good beneficial monetary use. Now, the most important thing, the first thing, whenever I get a call from a client, and I've had hundreds of landlord clients just in the past couple of years because of the onerous restrictions that have been imposed since COVID took place. The first question I always ask is jurisdiction questions, because depending on the location of the property, there's going to be varying sets of rules. And there are complex web of rules that have been imposed. So we have to take a look at city rules, we have to take a look at county rules, and we also have to take a look at statewide rules and regulations that may impact the tenancy and what landlords are able to do or not to do. Today, I'll mainly be covering the county of Los Angeles and the city of Los Angeles, because that's probably where the primary number of our guests here today are from. So first, before I get into the COVID issues, which again, I think are top of mind for a lot of people, I'd like to discuss the city of Los Angeles rent stabilization ordinance. So the RSO generally applies to multifamily units. So any property that has more than 2 units within the parcel, and properties that were constructed prior to 1978. And that's a vast majority of properties here. It's very important that whenever I get a client and they say, hey, can you evict my tenant? The first thing I ask them is, are you in compliance with the RSO? And the RSO has a laundry list of things that landlords and property owners have to do to be in compliance. And if you're not in compliance with those rules, you're not permitted to evict a tenant. So I make sure that my clients, when they come in through the doors, that they've checked off all of these prerequisites in order for my office to take over and get these pesky tenants out of the properties. The first thing that I'm sure most, if not all of our guests today know, that the properties have to be registered with the housing department. Okay, that's number one. Number two, once you register and you pay the registration fee, you must post the registration certificate in a conspicuous place within the building. Typically, that's near the mailbox or near an entrance door of the property. And I can't tell you how many clients come through my door who have not fulfilled these requirements. And unfortunately, the legislature, I should say the city council, when they enacted the RSO, they've imposed very stiff penalties for a landlord's failure to comply with those requirements. First, as I mentioned earlier, you're unable to evict. The statute provides an affirmative defense for any eviction action where the landlord hasn't complied with these requirements. Second, you're not allowed to collect rent. You're technically not allowed to collect rent. Third, and this is maybe one of the biggest penalties that are imposed, you expose yourself to treble damages. The tenant can literally file a lawsuit for a violation of the RSO if you have not registered the property, you have not posted a registration certificate, and they can seek to claw back not only all of the rent that the landlord's collected during the term of the tenancy, but also treble damages, which is 3 times the amount that has been collected. And I've actually litigated cases on behalf of tenants before where I've clawed back a ton of money where landlords have not complied with these requirements. And lastly, there's a one-way attorney's fees provision. If a lawsuit is filed to claw back that rent when a landlord has not fulfilled the requirements, the tenant additionally gets to recover every penny of attorney's fees expended in that action. And we know why they've imposed these requirements. They want to make sure the landlords register their properties, they pay their fees, and they post a registration certificate. So it's really important that landlords adhere to these requirements because there's some stiff penalties if they fail to do that. So that's just a general overview of the City of Los Angeles RSO. Now, everyone knows that we've been in this COVID mess since March 2020. It's been 3 years that has been going on. And since COVID hit, both the City of Los Angeles and the County of Los Angeles, they've imposed very strict requirements on a number of different things: failure to pay rent, unauthorized occupants, unauthorized pets. There's a whole laundry list of things that have been restricted. So I want to just have a brief discussion on those and then also discuss what the status of the current law is now. Now, the County of Los Angeles moratorium, this was memorialized in the Tenant Protection Resolution. That's the title, the fancy title that they have. But really what it was a moratorium against evictions. What it did bar, like I said, it barred evictions due to failure to pay rent. It barred evictions for unauthorized pets and occupants. So tenants could literally move in an entire family, their cousins or uncles or nephews. And there's restrictions on evicting them, even though the lease agreement prohibits it. Now, my clients, they call me and they tell me, there's a moratorium, I can't get this person out. And I tell them to slow down because you really have to take a look at the text of the resolution in order to do a particularized analysis and determine whether or not the privileges apply, the protections apply, and there's specific qualifications that have to be met. Not all tenants under the sun are entitled to the protections provided by the resolution. Under the county moratorium, the tenant has to provide a tenant declaration of financial distress where they state under penalty of perjury that I've been impacted financially by COVID. That declaration has to be provided within 7 days of the rent due date. If a tenant does not provide that declaration, technically they're not entitled to the protection. So that's one of the first things we ask when we get a new client and we're assessing the situation. The second requirement is that there's an income limitation. If you have a very wealthy tenant who's paying 20 grand a month, who's making $1 million a year, the protections do not apply to them. It's actually a very small subset of tenants to whom the protections apply. They have to earn approximately less than $68,000 a year for a one-member household. Okay, if your tenant earns more than that, they are not entitled to the protections for the resolution. They have to actually incur COVID-related financial distress. In other words, they have to actually be impacted by COVID. And lastly, they have to have a drop in income of at least 10% from pre-pandemic levels. If they can't, and this is something that happened kind of recently back in December, the county was sued based off of a contention that the moratorium was unconstitutional. And the Board of Supervisors came back and said, okay, now we're going to force the tenants to actually prove that they've been impacted by COVID. So it is an affirmative defense. It is on the burden and obligation is on the tenant now to come in and say, I meet the income requirements. I've suffered a loss of income. So what we do when we file a lawsuit, the burden is on the tenant to come in and prove that. And as we know, there's a lot of fraud going on. Many tenants have sought protections, but they just can't prove it at the end of the day. So it doesn't apply to everyone. That's really the message I'm trying to get across here. And lastly, everyone wants to know, when is this thing going to end? They've had a sunset provision, the expiration date for the moratorium many times. It was supposed to expire last June, and then they pushed it off to December. It was supposed to expire in December. They pushed it off to January. We have a current end date of March 31st, just at the end of this month, where we're all hoping that this resolution finally comes to an end. I can't make a guarantee of that because they have, it's been a moving goalpost this entire time. But we're hoping that it does finally come to an end in just a few short weeks. That covers the county. And by the way, it applies to the entirety of the county, not just the unincorporated region. So it'll apply to the city of Los Angeles as well. And strangely enough, although the county moratorium applied to the city of Los Angeles, the city of Los Angeles also, I apologize. Before I get into the city of Los Angeles, I just want to give your viewers insights into what things will look like right after the expiration of the county moratorium, because they've imposed a few new requirements. Even when the moratorium expires, what the resolution states is that if you're seeking to recover back rent that accumulated between July 2022 and March 2023, you are no longer allowed to issue or serve a 3-day notice. Since time immemorial, and especially since I've been a practicing lawyer, it's always been a 3-day notice, short period of time. Now what we're required to do is issue a 30-day notice, which will give tenants a tremendous amount of time to comply with the demand and pay the money. So they've altered it from a 3-day notice to a 30-day notice. And that 30-day notice also applies if you're seeking to evict a tenant for unauthorized occupants and unauthorized pets. Both of those previously required only a 3-day notice. Now a 30-day notice has been implemented. So that's really important to know, because if you're trying to evict someone in April, you got to make sure you comply with the notice requirements. City of Los Angeles, even though the county had a moratorium that applied to the city had its own moratorium that was actually much more onerous. And I don't need to necessarily get into the specifics of the city, because I have great news. The city moratorium came to an end February 1st, 2023, just last month. Okay, so on the city level, the tenants are no longer protected under the moratorium, but the county protection is still there until the end of this month. However, when the city terminated their moratorium, they've imposed new requirements as well. And this applies to all properties in the city of Los Angeles, not just rent stabilized properties, not just RSO properties. Any tenancy that commences from January 27th, 2023 onwards, or any renewal of tenancies, landlords are required to provide a tenant protection fact sheet that literally conveys to the tenants all of the new protections that have been imposed on all real property in the city of Los Angeles, both RSO properties and non-RSO properties. And the biggest item of that, see the difference between RSO properties and non-RSO properties was that you were required for RSO properties to have just cause. You had to have a basis, some sort of violation of the lease agreement in order to evict. That did not apply to non-RSO properties. Well, now it does. All properties in the city of Los Angeles are now subject to just cause eviction requirements, which means that you cannot voluntarily terminate a lease unilaterally anymore. You have to have some sort of violation of the lease, either the failure to pay rent, unauthorized pets, unauthorized occupants, modifications to the property, so on and so forth. You have to have a reason. And now the city has kind of usurped the role of Big Brother. Now they've also imposed a requirement that anytime a notice is served upon a tenant to terminate a tenancy, a 3-day, a 30-day, a 60-day, a 90-day, whatever it is, the notice must be filed with the city. So they're made aware of the landlord's efforts and intent to evict the tenant. Okay, if you do not send that notice to the city, you're barred from proceeding with an eviction action. Okay, so these eviction actions have become highly technical, and we make sure to check off every single box under the sun to make sure that we're firing off on all cylinders and we can get the job done. Now, the biggest question in everyone's mind, let's call a spade here, is when can I get my money back? I've had some clients, they come into my office literally crying because they have mortgage payments to make and they haven't received a penny in rent in over 3 years. They're literally on the brink of foreclosure or bankruptcy. They've still had to pay their insurance. They still had to pay their own mortgages, electricity bills, so on, maintenance costs, all of this. They just haven't received their money. So they want to know, when can I get my money at the end of the day? Well, just last month, new requirements were imposed. They're not as stringent as I expected. They're a little bit more favorable to landlords, which shocked me in light of everything else the city and the county has done. But for rent that accumulated between March 2020 and September 2021, the tenant is obligated to repay those funds by August 1st of this year. Okay. If the tenant does not repay those funds by August 1st, you can evict him for the failure to repay the back rent. For rent that accumulated between October 2021 and March 2023, you have to wait basically a year from now, about 11 months, to February of 2024. Okay. Now, what's important to note is the repayment period only applies if the tenant qualify for the underlying protections. So that's what I talked about earlier, the income limitations, the drop in income, and the requirement for them to provide the declaration of financial distress. If they don't qualify, their rent is due now. We do not have to wait until August. We do not have to wait until February of next year. And one strategy that my office has been employing, everyone's focused on evictions, but if you really want your money, we've been filing breach of contract actions. That doesn't necessarily have to do with regaining possession of the property, but it has to do with collection of the back rent that's owed. And a lot of the times that's enough to force the tenant to come to the table where we reach a mediated or a resolution with the tenant, a settlement agreement with the tenant for payment of the back rent and for them to vacate the premises. rental increases also has to do with money. And this has also been a moving target over the last 3 years and has caused a tremendous amount of confusion for a lot of people. But we know this stuff inside and out. For RSO properties, City of Los Angeles RSO properties, in normal conditions, not COVID conditions, not moratorium conditions, you're typically restricted to about a 3% increase or 80% of the local CPI. Okay. However, no rent increases for RSO properties right now are allowed, and they won't be allowed until February 2024, unfortunately, even though there has not been a single rent increase for the past 3 years. Now, I don't have a slide for the county, but for the county, and I'm talking about unincorporated areas of Los Angeles County, so long as the property is not subject to the LA County RSO, rent increases are permitted for those properties. Okay. So a lot of people think that it's a blanket prohibition, but it's not a blanket prohibition. It really depends on the jurisdiction and the location of the property. And lastly, I just want to discuss some creative solutions that my office has been pursuing in the context of all of these restrictions and requirements that the city and the county have imposed over the last 3 years. Unauthorized pets and occupants. Okay. Although the resolution and the moratoriums, they provide that a landlord is not allowed to evict for unauthorized pets and occupants, there's a qualification for that. The unauthorized pet or the occupants, their presence has to be, quote, necessitated by COVID. Okay. And I filed lawsuits. I filed many eviction actions, and the tenant has never been able to prove that my uncle had to move in here because of COVID. COVID ended a long time ago. So we've effectively evicted tenants for unauthorized and pets for the last 3 years. The second thing I ask my clients is, hey, can we find another lease violation? Have they modified? Have they broken a wall? Have they put up a wall? Are they improperly parking their vehicle? Have they damaged the property? We try to identify other lease violations that could serve as a sufficient and lawful basis for an eviction, and we're quite good at identifying those bases. The third bullet point on this, on the PowerPoint, is something that just came up this past month when the City of Los Angeles moratorium went away. For properties that have received, or I should say for landlords and property owners who have received government orders for violations of the building and safety code. In other words, a garage was converted without a permit, or there's some other violation in the property. During COVID time, you were not allowed to evict the tenant to comply with that government order. Well, that is back on the table now, and it's actually very effective because you have a government order that tells you need to put this property back in its previous condition. And now you're allowed to issue a 60-day notice to the tenant, asking them to vacate. And if they don't vacate, you can file an eviction action to get rid of them in order to comply with the government order. The catch to that, which in many instances is not a big deal, relocation fees do have to be paid to the tenant. Those range from anywhere from about $9,000 to $22,000. But what I found is I have clients who are elated to pay 10 grand to get these tenants out because they're losing a lot more on the back end, not being able to recover their rent timely. So we've had quite a number of cases coming through the door in the last month on these government compliance orders. And lastly, security deposit violations. You have a right to amend the lease agreement. Okay, and this is for non-RSO properties. I want to be clear about this. You have a right to amend the lease agreement in order to set the security deposit amount at 2 times the amount of the rent. If your tenant has not paid 2 times the amount of the rent or doesn't do so based off of the notice we would provide them, that would constitute a lease violation that would give us lawful grounds to evict the tenant. So all of these strategies we've used up and down, and they've been quite effective, and we've been able to, restore possession of properties back to landlords so they can get it back on the rental market and start earning income, badly needed income. And with that, that basically concludes the presentation today. I want to thank you for an opportunity to speak with you today and kind of shed light on these issues.
Wow, Edrin, thank you so much. That was excellent and very concise, but yet very thorough all at the same time. And man, I really appreciate that.
My pleasure.
Could you stop sharing your screen and then we can see you better? And guys, if we can get a split screen or something, that'd be great.
There we go.
Awesome. Awesome. And so I think we have some questions that I'm going to need to look real quick.
Sure.
Okay, I'm going to pull this up and try to make it smaller. There we go. It's LA County. Will we be able to start evicting for too many people? People not on the lease, pets, etc., starting April 1st. You just answered the question, didn't you?
Yeah, I sort of, and I want to be very clear about this, okay? Yeah. There's two requirements, okay? First, the resolution states that you're not allowed to evict for unauthorized occupants and pets, but that's so long as their presence is necessitated by COVID. I had a case the other day where a female tenant moved in her new husband. Okay, the guy ended up being a sex offender. Okay, and I tried to evict her. I did evict her, and she said, "No, COVID, you can't do it." I said, "His presence has nothing to do with COVID. The reason, and you admitted this, the reason he's in there is because you just married him." And I was able to effectively do it. So the answer is yes, but we have to assess the situation. And remember, you're now required to provide a 30-day notice, not a 3-day notice, in order to get that done.
Awesome. That's great. I'm having a little, my screen's kind of going, mine's a little jerky. Hopefully yours is not. So like you cut out, but I'm thinking everybody can hear it except me. But here we go. Thank you.
Of course.
Okay? Now everything seems like it's cut up on my end. So apologies, everybody. Manak, we have on YouTube. I have a single family residence in the city of Santa Clarita. I want to sell this property. Can I give 60 days notice to my tenant and have no fault eviction without paying any expense on April 1st, 2023?
I have to check. Santa Clarita is part of LA County, if I'm not mistaken. If it is part of LA County, not City of Los Angeles, okay? Yes, you're allowed to get further extended, okay? You're allowed to, in April, single family property, LA County, not subject to other rent stabilization ordinance, and assuming that the moratorium goes away, you should be able to issue that 60-day notice in April. And I'm also going to assume that the statewide Rent Control Act does not apply. That's the Tenant Protection Act. Like I said, there's various layers, city, county, state. I'm going to assume that the state Rent Control Act, AB 1482, doesn't apply either, okay, which also imposes just cause eviction requirements. If none of those apply, then yes, you can issue a 60-day notice and terminate the tenancy voluntarily.
Right. And with all of this, you know, these are general things, sure, and you're not being paid to give legal advice at the moment. There always can be some little thing, but that's a great answer, I think. And
as a lawyer, I always, my favorite answer is maybe, because there's a lot of facts that I need to know to assess the situation to give a more precise answer. And that's why I qualify my responses with, I need to know more information about the property and ownership and all of that.
Right. And here's Linda. I have a 12-unit building in unincorporated LA County. Is the rent freeze over on March 31st, 2023? If so, can I serve a 30-day notice now for a rent increase And we're a little too late for the April 1st rent increase. It's been over it would be less than 30 days, right?
Let me answer that. And you're going to love this. It depends. I need to know whether or not the unit is subject to the LA County RSO. And the LA County RSO is actually a little bit different than the City of Los Angeles RSO, because it has fully covered properties and it has partially covered properties. Because there's two impositions. There's two things that the county RSO does. It does a rent cap, and then it has a just cause eviction requirement. If the property is not fully covered, in other words, it's not RSO or it's partially covered, where it's not both rent control and just cause, you're allowed to increase rent now. Okay. If you go above 10% on your rent increase, you have to give a 90-day notice. If you go below 10%, it's a 30-day notice.
All right, there you got it. Angelo on YouTube, I made a mistake on the rental agreement. I marked the two boxes on the AB 1482 portion. So one of those boxes, this is the AOA lease agreement. One of them it's exempt. The other one, it's not. So what should he do?
Okay, so I'm hoping that it's exempt. So if it's exempt, just issue a notice of exemption. Okay, and a withdrawal of that previous notice that you sent. I mean, you're not, stuck in that position just because you accidentally checked off the box. The law is not that onerous. So you just do a notice of withdrawal, and then you do another notice of exemption issued with the proper box checked off.
Okay, here we go. YouTube, Massis. In the city of Burbank, if we terminate a Section 8 tenancy for renovation reasons after April 1st, do we have to pay tenants the relocation fee?
I need to know a lot more information to answer that question. I'd have to see the Section 8 agreement, because Section 8 has literally an agreement by itself. I have a lot of landlord clients who do Section 8. Sometimes there's a requirement that you're not allowed to unilaterally terminate it. Sometimes there's a requirement that you have to pay relocation fees. Assuming that none of those things apply, and assuming further that this is not subject to any RSO, okay, and assuming further that it's not subject to the statewide Rent Control Act, you should be able to voluntarily issue that notice, yes.
All right, there you go. Monica.
I wish I could provide more precise answers. There's just so much that are, and I don't want to misinform people, because I just need a little bit more information on some of these questions.
No, I appreciate that. And I think they appreciate it too, because even your answers are still very clear, and you're explaining enough to where it gives them context to be able to either figure it out or give you a call. Right?
Sure, exactly.
And just curious, if this is my own question, I know that that everybody's slammed right now. And so I'm kind of curious for you, if someone calls your office, what can they expect? Can they expect to talk to somebody immediately, or is it going to be more like within 24 hours? What could they expect?
No. Any new client or existing clients come directly to me. I try to give as personalized attention and services to my clients as possible. I know a lot of other firms who have, 10, 12 lawyers that are just out of law school that these, landlords are passed off to when they come through the door. When you come to our firm, you come directly to me. So I'm going to be controlling the cases myself, and they'll be able to reach me immediately.
Okay, look at that. Rachel on YouTube. If I have a single house in Tarzana, do I need to register my property?
The answer is no. I'm actually from the Valley. I used to live in Encino. I'm very familiar with Tarzana. Based off of the facts provided to me, the answer is no. I mean, a single family property does not have two. Again, I would ask whether or not there's an ADU in the property. That's going to change the equation a little bit, because then there's two dwellings that might make it subject to the RSO. But if it's just one single property, one house, one home, it should not be subject to any RSO, and therefore there would be no requirement for registration.
Great. Bill on YouTube, how do we know if the tenant has filed a declaration of financial stress?
Well, you would know because they have to hand it to you.
Yep.
They don't file it with the court. They don't send it to the city. They have to give it to you. They have to mail it to you, email it to you, hand it to you personally.
Right. I love that we're able to do this right now. Thank you so much for answering these questions.
Of course.
We got a ton more, so just let me know how long we can go. We'll just
you go as long as you need. You go as long as you need.
We'll just we'll run with it if you can.
Sure.
All right, Mrs. W, City of LA. The tenant submitted an old LA City self-certification form in February. If she does not submit the LA County self-certification this month, can I move forward with an eviction?
The answer is probably yes. There's a requirement to provide that because, see, the city moratorium is gone, all right? So now the county comes into the fold, and the county requires a declaration to be delivered to the landlord within 7 days of the rent due date. Now, the wonderful members of the County Board of Supervisors, what they've done is they have a little blurb in that resolution that says if the tenant fails to provide the declaration and that failure was due to, quote, extenuating circumstances, whatever the hell that means, nobody knows what it means, the tenant may be able to come later on down the road and give the declaration to cure the previous failure, okay? I've seen that happen a little bit, but we have fired off lawsuits successfully when the tenants have not timely delivered those declarations.
Great. Yeah, and I mean, one of the extenuating circumstances that I could think of is they were hospitalized for over a week, and it just happened. So there are very, very few. Very few.
There are. They have a statutory requirement to provide that timely. And yes, hospitalization, something along those, car crash, whatever it is, that would prevent them from doing so.
Right. All right. Brian on YouTube. I have a fourplex in El Monte. The city has no rent control. So I wonder if Los Angeles County has any restrictions on rent increases besides the state restrictions.
Assuming that the property is not subject to the LA County RSO, okay, then the statewide Rent Control Act, because this is a multifamily property, it's a fourplex, the statewide the Tenant Protection Act would apply, and that is capped at the greater of 10% or 5% plus the change in CPI. Okay, so it's typically around 10%, and that's the ceiling that's going to be imposed.
Great. Okay, Brenda, does Inglewood, Hawthorne, and Long Beach fall under LA County? So that would be a yes, right?
Yeah, I think so. I think all three of them, because Long Beach is right before Orange County. I think all three of them fall under LA County.
All right, we love LA.
Which is kind of terrible because when you go out to Orange County, no restrictions, none of this, this stuff. And if you go out to Ventura County, also none of this stuff. Neither side has really imposed anything since the onset of the pandemic, which is great for property owners there, but terrible for property owners here in LA.
Right. Okay, Diane, property is a single family home built in 1950 in the city of LA, not RSO. If so, can I raise the rent? How much and when? Oh man, bad news for Diane here.
It's a single family property, non-RSO. She can increase the rent. She can increase.
LA, did she say LA City?
Yeah, it's LA City, but the LA City only applies to RSO properties.
That's right. Okay.
And so long as it's not an RSO property, you can. But my question to you would be, is the property subject to the Tenant Protection Act? Now, you're telling me it's a single family, and there is an exemption in the Tenant Protection Act, but that only applies under two conditions. One, the property is owned by a natural person. In other words, not a corporation. Okay. And two, you've provided a notice of exemption to the tenant. If you check off both of those boxes, then the statewide rent cap doesn't apply. The city rent cap doesn't apply. The county rent cap doesn't apply, and you're good to go.
Right. And if you haven't submitted that form, definitely, no matter what, whether you're needing to evict or not, just get that form submitted to your tenants if you're exempt for sure. So.
Absolutely.
Slavika, my tenant self-certified hardship due to COVID every month, but no proof of it.
Okay, so we need to know if, we need to know where the property is located. I need to know whether it's the city of Los Angeles or the county of Los Angeles. Because if it's, and I need to know what time frame we're talking about. If we're talking about after February 1st, 2023, the city moratorium is gone. And by the way, the city moratorium never required the tenants to prove that they incurred financial distress. It's the county one. The city moratorium was much more onerous. That's gone now. The county requires the city. It is the burden. It requires the tenant. It is the burden of the tenant to prove the financial distress. It is an affirmative defense, and the burden is on the tenant to come into court and say, I make less than $68,000. I've suffered more than a 10% drop in income from pre-pandemic levels.
Right. And that was, we sued LA County with AGLA. We had that lawsuit, and we're actually cranking it back up because they extended it this other time, and we thought, oh, we'll just kind of let it be. But we actually are we're preparing papers to file for summary judgment. I don't know if you knew that or not.
I did. I was unaware of that. No.
And then also to hold them in contempt, because, they didn't really comply with the judge's orders, in our opinion.
They didn't. And thanks to the AOA and AGLA for getting that federal judge to deem the resolution unconstitutionally vague. Only because of your efforts did the county come back and finally define what financial distress meant. Before, everyone was guessing, is a 1% drop enough? Now they've said you need at least a 10% drop in income, and it has to be proven by the tenant.
Right. And anyway, so that's coming up, and that does take cash. Attorneys don't work for free, unfortunately. So AOAUSA.com/PAC, PAC, if you'd like to contribute to the cause there. And there's a lot of other stuff that come up that we'll be able to fight. It's lawsuits, and it's also just getting the word out on different propositions and things that are going on. And we do not lobby in the sense of paying somebody or paying officials, but we do spend it on lawsuits and on just getting the word out there on how destructive certain bills might be, and getting people to vote in a way that will protect the housing industry, protect true affordability. And then also, I just want to mention that we made a correction a little while ago. We had maybe we had a different email address up, but the correct email address for SNS Law Group, it's info@snslawgroup.com. And that's probably on the lower third there, where you could, at the bottom of the screen, you should be able to see that. And anyway, so take care of that housekeeping. Property manager here on YouTube. What should we do when an Airbnb guest overstays 30 nights and claims tenant rights?
Well, I've actually have dealt with that quite a bit as well. There's a distinction in the law between tenants and lodgers. Okay, and all of these protections that the past hour I've been speaking to, they only apply to tenants. So the whole set of other requirements that are far less onerous, far less restrictive than tenants' rights for these short-term rentals. So you do have a very good shot at getting rid of these people, especially if they came through the Airbnb app and there's no separate agreement between you and them.
Great. Okay. Armando in Downey, single-family home with tenants and unknown adults. No rent paid, 3 days served with tenants and all those in possession, in quotes. How are unknowns served with summons if inaccessible? Seems impossible requirement to evict.
It's and the legislator a very long time ago addressed this issue, and this is a fantastic question. And as landlord attorneys, we have a very powerful tool in our toolbox. When we file complaints, okay, we don't know. Imagine an entire family is brought in. You don't know the identities of those individuals. You can't specifically name those individuals in a summons and a complaint. What CCP, and this is California Code of Procedure 415.46, I'm not mistaken. It allows a landlord or a landlord's attorney to serve what's called a prejudgment claim of right to possession. Okay. It's a form that gets served on the tenant, the named tenant, at the time the lawsuit is served. And what that does, it puts the onus on those unnamed occupants to appear in court within 10 days of service of that prejudgment claim of right to possession in order to assert their rights to possession. If they don't come into the action within 10 days, my office defaults those unnamed occupants and they are captured within whatever judgment comes down the pipeline. So when we get a judgment, that prejudgment claim of right to possession was served, the default was entered. When the sheriff goes out there, they'll kick everyone out. Doesn't matter if they're named in the complaint or not.
Great. Jamie on YouTube. Can I still evict a tenant with a tenancy of less than a year using a 30-day notice, even with the LA County COVID protections in place?
I need to know what type of property it is and where it's located. When we talk about the state level, okay, the state level only kicks in once the tenant's been there, once they have a 1-year lease or they've been there longer than 12 months. So I need, typically, under typical circumstances, the answer is yes. I don't know exactly where the property is or what type of property it is, but you should be able to, depending on those other factors that I'm unaware of right now.
So give them a call.
It's difficult to answer, and I don't want to misinform people without knowing some additional facts.
Exactly. And so it helps. The more information you put in, the more accurate an answer we can give for you. In LA, evictions for unauthorized occupants, does fire safety civil code an affirmative defense for eviction, i.e. 10 people in a 2-bedroom unit?
Well, I think this goes back. This goes back to my other point about government compliance orders. Assuming that a government compliance order was issued in order to comply, saying this is a fire hazard or whatever it is, you're able to evict a tenant now. Starting back in February, that's opened up again. You just have to go through the proper channels. You got to file the declaration of intent to evict. To comply with the government order, you got to give out the 60-day notice and then pay the relocation fees.
All right. Eric, can I evict based on nuisance? He's not telling us where he's at, but it's an additional tenant, which you've addressed, so we won't talk about that one. How about just this part? The parking in front of the lawn, putting stuff in the carport, so there's lease violations. Can they evict for that?
Oh, yeah, absolutely. Absolutely. And those are the things that we try to do to get creative in order to evict these tenants. We try to identify exactly those types of issues that are not protected. See, when we talk about nuisance, improperly parking your vehicle doesn't fall under a nuisance. It's a lease violation. That's what it is. Storing a bunch of items in an improper location that may create a fire hazard or prevent ingress and egress, exit and entrance to the property. Those are lease violations that would give you sufficient grounds to evict.
Great. And even we talked about it even at 10 a.m. We had common code violations, California building code violations, and we talked about that. You need to have a 3-foot path to exit the building and get through. So exactly. Great point. Eliza, LA City and County. If someone has been living in an unpermitted unit, which I haven't taken rent for, and they made a hole in 2 places in my property, damaging my property, is that grounds to evict?
Excellent question. And the answer is no. Okay. Now I want to be clear about this. When we're talking about making holes or damaging the property under normal conditions, if you have a lease agreement, everything's permitted, there's a certificate of occupancy, you can absolutely evict. Unfortunately, when there's no certificate of occupancy or the place was built without permits, the LA Municipal Code, what it states is that the tenants are granted an affirmative defense to any eviction when the landlord has not procured a certificate of occupancy. Okay, so you're not going to be able to evict because of the damage to the property, but you will be able to evict to comply with a government order, because the building and safety department is going to get on you and say, you're allowing people to live there. There's no permits. There's no certificate of occupancy. You need to convert the structure, the guest house, back into its prior condition. And to do so, the tenants need to go.
All right.
And we've helped a lot of clients, by the way, in the last month, and they've been elated. Although they have to pay the relocation fees, they finally have an avenue to get rid of these people.
Right. And, and that's so that's a tough one. But man, it's nice to be a little bit more free.
Yeah. Certainly.
Some rights restored, some of them. All right, Karen, if a tenant has not provided a declaration of COVID hardship within 7 days, can they just make that attestation at court as an affirmative defense?
Like I said, it depends. They're technically required to provide it within 7 days. Okay. The exception to that is if there's extenuating circumstances that resulted in their failure to timely provide that declaration. So the answer is maybe. I know that's not a satisfying answer, but it is an answer nonetheless. The answer is maybe, and it depends on their excuse. Some judges will look at it and say, getting drunk on your couch is not an extenuating circumstance. All right. So it depends.
Okay, here we go. Perry, which renter protection lists are exempt for 4 units or less? Am I reading this correctly? We're not sure what you're reading, but which renter protection lists are exempt for 4 units or less?
I'm not sure what the question is asking. I'm not sure what lists he's referencing.
So I'm with 4 units. Is 4 unit the cutoff for AB 1482?
No, it's any multifamily.
Okay, now I wonder if there's a 4 unit cutoff. Which one has a 4 unit cutoff? Maybe that's the threshold. More than 4 units, it's maybe it's for the RSO. She's thinking of. Yeah, we're not sure what.
It's never a 4 unit. It's never a 4 unit. It's always a 2 unit.
Diane single family resident, City of LA, with occupants over 62. Over 5 years in the property. Can I sell without paying relocation?
Oh, well, you can always sell. Selling the property, I mean, you have an absolute right to sell the property anytime you want. The tenants have a right to stay, even though there's a transfer of title to a prospective buyer. The better question is, are you able to evict because of a potential sale? And the answer to that is no. You still need a sufficient lawful basis to evict the tenant, and selling the property is not a sufficient lawful basis.
Okay. I have a 22 unit building in the City of LA. We have a $200 fee for adding a person to a tenant's unit. When can I charge this fee?
The fees there, you should be able to start charging the fee in April once the county moratorium goes away, because the county moratorium prevents the assessment of any fees in addition to any rent increases. Okay. I don't know what it's going to look like post April 1st. I don't know if they're going to continue prohibiting that. The language of any subsequent ordinance or resolution hasn't been issued yet. But for now, you should be able to start in April once the LA County moratorium goes away.
And that's assuming she's not under RSO.
That's assuming she's not under RSO as well, yes.
Okay, Donna, thank you. ABD on YouTube. Can we serve a 3-day to any tenant who has met the threshold and did not pay for February and March rent, or does it need to be a 30-day notice to pay or quit?
Fantastic question. Okay, the 30-day requirement only arises after expiration of the moratorium, and arises in April. Okay, so you can right now, today, we're not in April yet, you can issue a 3-day notice, even for the back rent that accumulated during the COVID-related back rent. Once April 1st comes around, that shifts to a 30-day notice.
That is such a great question. I love
It's a
that.
fantastic question. Fantastic question.
Okay, Sandy on YouTube. My 6-unit building is in LA City and is under RSO. Rent for a 2-bedroom unit is $21.50. The tenant has never formally notified me of COVID, but did verbally mention it on 6/2022. No payment since September of 2021. Can I evict?
You can. This is also a great question, and this is kind of unraveling the different layers of protection. The city moratorium went away February 1st. The city moratorium never imposed a requirement of a tenant providing a declaration. That was always under the county requirement. So if you want to try to go back and get your rent or evict for rent that arose prior to February, not a good idea, because that's protected by the LA City moratorium. If you want to look at February rent, which only falls within the auspices of LA County, they're required to give you the declaration. They didn't give you a declaration. You have sufficient grounds to evict them.
Right. And that 2-bedroom and the rent's $21.50. The minimum threshold is $2,222. Here we are. They still haven't paid, and we're in March. So now they owe over that threshold of $2,222, and that's why you're saying it, not just because it's the $21.50.
Correct. Yeah. It has to because of the other ordinance that the city passed, which has put together this absurd, artificial number. They once you count both months, February and March together, then it surpasses that amount.
Right. Ruth here on YouTube. I have 3 units in the city of Long Beach. It is under rent. Oh, I have 3 units in the city of Long Beach. Is it under rent control?
There's a very easy way for us to figure that out. And that's going on a website called ZMIS. That has a full directory of all city of Los Angeles rent controlled properties. County of Los Angeles does not have an online database. You have to contact the Consumer Affairs, Business and Consumer Affairs office.
There you go. Margaret, when can we ask for late payments? I have one tenant who always pays at the end of the month in San Pedro.
You were not allowed to impose late payments. It's not even a question of collection. You weren't allowed to impose late payments during the pendency of the COVID-19, the LA County Tenant Protection Resolution. So assuming that it goes away April 1st and they're late again for April, then perhaps you can impose it for April.
And that's if we understand your question correctly. We may or may not be getting your question. I'm not 100% sure that we are. All right, Christian. Can I evict a tenant for having unauthorized pets when the pets are vomiting on my other tenant's front door and scratching the top of their cars? Tenants for over 10 years, over 62 in LARSO.
I think you should be able to. Yes. I mean, my question to you would partially be, when do those pets first come in? Does the lease allow for pets? But even if the lease allows for pets, it doesn't allow the pets to cause damage. And if you've notified the tenant of the issues and it keeps happening over and over and over again, I think you have sufficient basis to get it done.
Hey, we're at 2 hours here, and man, there's still more questions, and I don't want to keep you for more than 2 hours. Oh no, it was one. We started. An hour. No, we only did an hour. Okay, we're good. Yeah. So, are you still okay on time? I mean, I know you have a schedule.
Yeah, absolutely.
Okay, just want to respect your time. All right. So, cool. So, Vinny, I have a single-family residence in the city of LA with a separate back unit. The front house and the back unit are rented separately to 2 different tenants. I tried registering the units with RSO, but could not, as I don't have a separate certificate of occupancy for the back unit. I need to evict the tenant in the back unit. How can I proceed?
Okay, so this is one of those problematic cases that I was talking about earlier. And what you're, and what I would want to know is whether or not the building and safety department has pursued him for constructing that separate unit, that ADU, constructing it without permits and not having a certificate of occupancy. If you do want to evict them, and this is going to sound very strange, what I would do is I would self-report. I would self-report to the building and safety department and say, hey, this place was built without permits. Issue a compliance order to me. Have one of your, and I know this sounds counterintuitive, but it's the best way to do this. Issue a compliance order ordering me to convert the place back to a garage or whatever it was. If your main intent is to get rid of the tenants. Now, you have to understand that if you get rid of the tenants and you want to re-rent the place, you got to go through the entire building and safety process to do everything through permits, exposed walls, so on and so forth. So, it's a cost-benefit analysis in terms of what the best option is for you. But that's probably the best avenue, is to get some sort of compliance order issued from building and safety.
Right. And this goes back to the live stream that we just did, where you try to save a dime and not getting it permitted, doing it yourself, and it just comes back to bite you like this. So whatever you're doing, even if it's a little job, get the permit for it, do it right, and just avoid the headaches. And so again, if you're an AOA member, it's exclusive. The man who set up the LA systematic code enforcement system is only speaking to AOA, only presenting on AOA. It's exclusive to AOA. We're going to have all 3 parts of that series in the member portal, I believe by tomorrow. And then along with Michael Brennan's habitability. Anyway, you're going to want to see those 3. He goes through so many of the different issues that come up. So I just want to plug that one again. Here we go. Okay. Nota, can I raise the parking fee? It's on a separate lease in the city of LA RSO.
So she has a separate parking lease. And I'm sorry, you said it's an RSO?
Yeah, city of LA, and it's an RSO unit.
Look, there maybe we can make an argument. Look, I hope the viewers recognize this. Okay, the county board of supervisors, City Hall, Los Angeles, they've been doing this on the fly, and when they do these things on the fly, the ordinances that they issue are not a model for clarity. They're literally doing it overnight. So many of these little nuance issues, perhaps they didn't think about, hey, do the tenancy rights apply to a parking agreement when we're prohibiting rental increases? I would have to take a look at the parking lease and know a little bit more to be able to answer that. So it depends on whether or not that creates a tenancy and whether or not it's pegged to a tenancy.
Mm-hmm. Commercial leases. If it were a commercial lease.
Oh, commercial lease is
over.
Completely different. I mean, commercial is a different galaxy than residential is. Right. We've been effectively evicting tenants, imposing rent increases, security deposit increases on commercial tenancies for the better part of a year now. For a long time now.
Angelo, I know that when the eviction process starts, the landlord cannot receive any payments. What if the tenant sent $1 payment through Zelle? And with that one, simple, just send it right back.
You put a letter together. What we do is we put letters together saying your tenancy's been terminated. We will not accept any further payments. Here's a refund.
There you go. Put a letter
immediately, because you don't want to give them any argument that you waived the notice or the lawsuit that you filed.
Right. Okay, Gilbert, can I evict a tenant in Downey City? He owes me 2 months of rent.
I'd have to know more about the type of property, when the rent accumulated, what period of time to be able to answer that. And I think I'd probably am able to take maybe one or two more questions because I have a hearing coming up and I don't want this judge to strangle me.
Got it. Here we go. You've been very gracious with your time. So thank you so much for helping out everybody.
My pleasure. My pleasure.
Okay. Now let's see. Julia, what if the city requires one rental agreement and not individual rental agreements between roommates? One roommate is refusing to sign. Is this enough to evict tenant?
So the landlord is renting it out to two roommates.
Sounds like it.
And only one of them is willing to sign a lease renewal. Well, that provides just cause. That's actually enumerated in the municipal code. If the landlord goes to a tenant and says, you're on a month to month, I want you to sign a new lease agreement. By the way, the terms have to be the same as the last one. And the tenant refuses to execute a lease renewal, that would give you just cause to evict them.
Great. And hopefully she's not saying that she got different lease agreements for each one of them. Everyone would, you just as a regular, thing is you just put everybody on one lease. You don't have multiple lease agreements going on, because then you have to have multiple evictions going on.
Yeah.
And hey, thank you so much, man. It was just a pleasure to have you
Likewise.
speak. We really enjoyed it. Everybody's so thankful. So why don't you give him a thumbs up for all the time that he spent with us and the excellent presentation that he put together, and make note of his email address and his phone number. Give him a call, and I'm sure he'll be able to help you out.
I just wanted to thank you for giving me an opportunity to present today. Again, we do eviction actions. We do a lot more than eviction actions. We do business litigation cases, real estate litigation cases, anything that has to do with business or real estate. We have under one roof here, and we provide effective representation, and we'd be happy to help anybody that'll call in.
Excellent.
Thank you so much.
Okay, Edrin. Take care.
You have an excellent day.
Okay. See you, everybody.
Take care.